Hello everyone, welcome to Immigration Update Desk. I'm your host Alex Grant. Since the start of 2026, conversations around marriage-based green cards have grown louder and, for many couples, more confusing. YouTube videos, social threads, forums, and even well-meaning friends are repeating half-facts that make it sound as if approvals have become impossible, that mysterious new rules are blocking cases, or that USCIS has secretly changed everything under the surface. When you're already waiting on an I-130 or a spouse's green card decision, the noise can create fear and paralysis. So before you jump to conclusions, it helps to slow down, separate verified facts from speculation, and understand what is actually happening inside the system right now. Yes, 2026 looks different from a few years ago. Scrutiny is higher, processing is more documentation heavy, and officers are expected to verify details across multiple data sources. But it's also true that genuine marriages are still being approved every day. Family reunification remains in U.S. law, and absolutely no announcement has eliminated the marriage-based pathway. What couples need is not panic, but a practical playbook. What changed, what USCIS is focusing on, what evidence moves the needle, what timelines are realistic, and how to prepare so you can navigate the process with confidence. Start with the foundation. A marriage-based case almost always begins with Form I-130 to establish the qualifying relationship, and from there you choose the path based on where the immigrant spouse is. Adjustment of status in the United States or consular processing abroad. Spouses of U.S. citizens are immediate relatives, meaning there is no annual visa cap, while spouses of permanent residents fall under F2A and must watch the visa bulletin. That part hasn't changed. What has changed is the level of documentation expected at each step and the consistency checks applied to every detail. Names, dates, addresses, prior entries, visa histories, and even tax filings are cross-checked across government systems, so the case you present must be clean, consistent, and credible. At the I-130 stage in 2026, officers are spending more time on relationship timelines, how you met, when and how you married, where you lived and for how long, and whether your story matches prior immigration records. Small inconsistencies that might once have passed without comment now trigger additional review or a request for evidence. A date that shifts from one form to another, a move that appears on one document but not on another, a prior visitor visa application that lists a different employer. These details matter. The response is not fear but precision. Gather a clear history of addresses and employment, choose one transliteration for names and use it everywhere, and if a real mistake exists, correct it with a short, factual explanation rather than pretending it didn't happen. Interviews are again more common. While some cases were waived in prior years to reduce backlogs, 2026 is seeing a steady return to in-person interviews, especially where a file shows any uncertainty. Prior overstays, previous petitions, short courtships, long gaps in cohabitation, complex travel patterns, or notable age or cultural differences. Interviews can feel more detailed because officers are documenting decisions more rigorously, asking about daily routines, shared finances, how bills are paid, how holidays are spent, future plans, how you divide responsibilities, and details of your wedding and life together. Nervousness is normal, but interviews are not designed to punish. They exist to confirm what your file already shows. The best approach is honest, concise answers that match your paperwork, supported by plain-spoken evidence rather than rehearsed speeches. Processing times in 2026 are longer in many places. That's not because Congress erased the category or because USCIS doesn't believe in marriage, but because staffing, caseloads, and review standards have tightened. Timelines vary widely by service center and local office, so two couples who file the same day can diverge depending on where their I-130 lands and which field office handles their interview. Treat posted processing times as ranges, not promises. and build your life around the outer edge of those ranges to reduce stress. Silence for a few months is not an omen. Many files move internally without visible updates on the public tracker. Financial sponsorship is under sharper scrutiny too. The affidavit of support is a binding contract, and officers are checking household size math, current income versus the I-864P poverty guidelines, tax transcript availability, and proof of U.S. domicile when the petitioner has been abroad. If a case has been pending for a while, be ready to show ongoing income at the time of adjudication, not just at filing. Use IRS tax transcripts when possible. They read faster and avoid confusion. Add W-2s or 1099s to clarify. Show pay stubs and employer letters for current income. And if you're short, secure a joint sponsor early and submit a complete I-864A if a household member's income is counted. If you live abroad, document a plan to reestablish domicile with job offers, a lease, school enrollment for kids, shipping receipts, bank activity, or voter registration. Weak I-864s are a top reason cases stall at both USCIS and NVC. For couples using Consular Processing, similar patterns are showing. Even after I-130 approval, interviews can take longer to schedule in posts where capacity is tight, where security reviews are higher, or where local conditions have slowed normal operations. Being documentarily qualified at the National Visa Center is not the finish line. It means you are in the interview queue and must wait for a slot while keeping police certificates and passports valid and your civil documents correct per the reciprocity schedule. A 221G administrative processing slip is not a denial, but a request for extra checks or documents. Respond precisely and avoid adding unrelated materials. Keep Email Watch active so you can attend medical exams and interviews as scheduled without rescheduling delays. None of these realities mean marriage green cards are impossible in 2026. The legal pathway remains, and approvals continue for genuine couples. What has changed is the level of patience and preparation required. Couples who stay organized, keep information consistent across every form, and answer USCIS or consulate requests completely and quickly are still moving forward. Delays do not automatically mean denial, and months of silence do not automatically mean trouble. Most often they mean your file is in queue. Travel deserves special caution. If you are adjusting status, do not leave the U.S. without advance parole unless you are in H-1B or L-1 and traveling under those protections, because departure without AP typically abandons I-485s. If you're a permanent resident waiting to file or waiting for an interview, watch trip lengths. Time abroad beyond 6 months can trigger questions about continuous residence for future naturalization, and absences of a year without a re-entry permit can be treated as abandonment. If you have any prior immigration violations or criminal issues, get individualized legal advice before traveling, because the 2026 environment includes more frequent secondary inspections and data sharing at ports of entry. Since success now depends on evidence quality, build your file with both breadth and authenticity. Beyond the marriage certificate, strong, ordinary evidence beats glossy collages. A lease or mortgage with both names, joint bank accounts that actually show regular activity from both spouses, joint tax filings where eligible, health and auto insurance naming each other, beneficiary designations on retirement accounts, utility bills, shared memberships, travel records and boarding passes, photos from different times and places with family and friends, messages or call logs that show day-to-day life, mail delivered to the same address over time, birth certificates of children, and affidavits from people who know you as a couple. Label everything clearly. If you provide photos, add short captions with dates and who is pictured. Avoid staged or identical photos, and avoid sending hundreds of pages that bury your strongest items. Quality over volume wins. Understand common red flags and how to address them with honesty, not theatrics. Short courtship followed by rapid marriage can be fine if supported by a credible timeline and family involvement. Living apart temporarily can be fine if justified by job, school, or lease timing and supported by travel records and messages. Prior marriages must be fully documented with divorce decrees or death certificates. Big age gaps or language differences are not disqualifying, yet they invite more questions. So be prepared to explain how you communicate and what your shared routines look like. A prior removal order, misrepresentation, or certain criminal history can require waivers. Know the standards and evidence for I-601 or I-601A unlawful presence waivers, fraud waivers, or criminal waivers, and do not file them casually. Extreme hardship evidence for qualifying relatives takes planning and documentation. Inside the United States, adjustment strategy matters. Some couples file a one-step I-130, I-485, I-765 for work authorization, I-131 for advanced parole, when the immigrant spouse is eligible to adjust. Immediate relatives who overstayed can often still adjust if they entered with inspection, but entry without inspection generally requires a different path, such as consular processing with provisional waiver possibilities or humanitarian parole variants. Employment-based violation history, false claims to citizenship, or certain entries can complicate the picture. Do not assume online anecdotes map to your facts. If you file a one-step, watch form additions and fees, answer the inadmissibility questions completely and truthfully, include a properly sealed I-693 medical exam, or plan the timing so it remains valid at interview, and track fingerprint reuse notices and interview scheduling in your USCIS account. If you rely on the EAD, file renewals early and keep your job informed about timelines. If your driver's license or SSN needs updates after work authorization, schedule those early to avoid gaps. For consular paths, the timeline adds the National Visa Center, where the DS-260, the I-864 financial packet, and civil documents are uploaded and reviewed. Match the reciprocity table exactly. Some countries require police certificates from national and local authorities, some accept online certificates only, some require court records for even minor offenses, and translations must be complete and certified. When the NVC issues a checklist, fix everything in one pass because each resubmission restarts the review clock. Once documentarily qualified, be interview ready. Keep documents current, save funds for the medical exam and travel, and plan how you will receive the passport after approval. Check the visa foil for accuracy and pay the USCIS immigrant fee online so the green card can be produced after entry. Because 2026 includes more detailed interviews, it helps to practice calmly. Do a run-through of likely questions with your spouse and, if needed, your interpreter. Agree on factual timelines rather than rehearsed scripts. Bring originals and one organized copy set of civil documents. The interview letter, medical envelope if applicable, updated financial evidence if income changed, and a tidy relationship binder. Arrive early, turn off your phone, and answer the officer's question directly. If a detail is unknown, say so and offer to provide documents later. If separated for a Stokes interview, stay calm and consistent. Officers compare facts, not phrasing, and inconsistencies from stress can be clarified if the core story is true. After approval, remember that marriages under 2 years at the time of admission or adjustment result in conditional permanent residence. A 2-year card is not weaker. It simply requires Form I-751 to remove conditions in the 90-day window before expiration. Start saving evidence now so your future I-751 shows a continuous good faith marriage. If life changes, separation, divorce, domestic violence, or widowhood, waiver options exist for I-751. VAWA self-petitions exist for those in abusive marriages with U.S. citizens or LPRs. Do not let fear keep you from seeking protection or legal options. Safety comes first. To avoid avoidable delays in 2026, adopt a few habits. Use the most current forms from USCIS on the day you file, sign everything in the right places, pay the correct fees with trackable methods, keep copies of every page you submit, and label exhibits clearly. Reconcile names and dates across all records before you submit anything new. If you moved, file AR11 and update your online account so notices arrive. If you receive a request for evidence, read it twice, outline each item, and respond with exactly what is asked and nothing contradictory. A 2-page cover letter that lists exhibits and points the officer to the right tab can save weeks. If your case is outside normal processing times per the USCIS tool, submit a service request, escalate to a Tier 2 callback if needed, and where appropriate ask your congressional office for assistance with a concise timeline and receipts. None of those steps forces approval, but they can surface misplaced files or trigger a stalled action. Meanwhile, do not let rumors dictate your choices. Viral posts claiming all interviews waived or all cases denied mislead. Look for primary sources, USCIS policy alerts, form updates, Federal Register notices, and local field office practices, and pair them with your facts. If your case involves complex inadmissibility or prior orders, get individualized legal advice. A brief paid consult with a qualified attorney is often cheaper than months of delay from a preventable mistake. The emotional side matters. Marriage-based processing is intimate and bureaucratic at the same time, which can be exhausting. Set a monthly immigration hour with your spouse to review status, receipts, and next steps. Keep a shared folder for documents and a simple spreadsheet of dates and actions. Celebrate small milestones, a properly filed packet, an online status change, a scheduled biometrics appointment, so the process feels like progress rather than pure waiting. Protect your mental health by limiting doom scrolling and choosing 2 or 3 trusted sources for updates. If family overseas is anxious, share a simple timeline and commit to a monthly update so the conversation remains structured and calm. As 2026 continues, USCIS may adjust internal practices and cycle through periods that feel slower or faster. The keys that worked last year still work now. Preparation, honesty, clarity, and realistic expectations. Genuine marriages are still being approved, families are still reuniting, and the pathway remains open for those who follow the rules and present clean, consistent files. If you are starting now, build your case like a story the officer can verify with documents at every chapter. If you are mid-process, tidy what you have, respond promptly, and keep living your life together in ways that naturally generate bona fide evidence. And if you are nearing the finish line, prepare for interview day with calm confidence and a clear packet. Immigration Update Desk will keep translating changes into practical steps so you can move forward with certainty. This content is educational, not legal advice, and individual facts matter. So verify details with official sources or a qualified professional. If you found this helpful, subscribe and tap the bell. Share this with a friend who needs a balanced, fact-based update, and join me, Alex Grant, in the next video where we'll walk through a full marriage-based checklist, forms, fees, financials, civil documents, medicals, interview prep, and the first 30 days after approval, so you can turn preparation into approval with less stress and more confidence.